common question that we get from clients is, well, what decisions do I get to make on my case because you seem to be doing everything? And in a criminal case, whether it's New York State or federal, a client only makes two big decisions. The first decision that the client makes is, do I take a plea or do I go to trial? As lawyers, we could tell the client what we think is best, but ultimately we're not fortune tellers. We don't have the gift of seeing the future and predicting to the client what happens. It's the client's decision, and we're happy to talk to the client about it, but the client is the one making the decision of plea versus trial. Now, the second big decision that the client makes in a criminal case is whether or not the client is testifying at trial or speaking at sentencing. As lawyers, we counsel the client on what we think the best choice to make is, but ultimately it's up to the client. And it's up to the client, and no one could compel the client to speak, and no one could also prevent the client from taking the stand at trial if that's what the client wanted to do. Everything else, hate to tell you this, is on the attorney. Discovery review, case strategy, what we're doing with the case, suppression motions, applying for bail even. These are all the attorney's decisions. And hopefully your attorney gets you involved with these other decisions that are part of your case. Some attorneys don't, we generally do, and I think the reason why we get clients involved with these other decisions is because the client feels heard, and it's better from a case management perspective where the client feels heard and they feel like we're doing a good job. But as far as your decisions go, it's only those two big ones, and everything else is on your attorney, so pick wisely.